unprecedented code of conduct for Supreme Court justices now one step closer to reality. After a party line vote in the Democratic-led Senate Judiciary Committee, the bill's advancement here on Thursday follows a series of reports into gifts, luxury travel accommodations that Justices Clarence Thomas and Samuel Alito received from wealthy conservatives connected to Supreme Court cases. Meanwhile, the Associated Press recently reported that Justice Sonia Sotomayor's staff has pressured event organizers to buy her book ahead of speaking engagements. We're now joined by Ian Samuel, who clerked for the late Supreme Court Justice Antonin Scalia back from 2011 to 2012. Ian, thanks for being here.
My pleasure. Thanks for having me.
I think it's important to remind viewers right off the top here that unlike the lower courts, the Supreme Court isn't bound by any formal code of conduct, right? But I got to say, there's still this back and forth over whether or not justices broke government ethics law. And can I raise my hand and say I'm also one of the ones who's a bit confused here? Can we start with the legality of this? And what say you? Did they or did they not break the law?
Well, it's not clear that they broke the law because it's not clear that there's any law that governs their conduct in this scenario. In fact, it's pretty clear that there isn't. The Supreme Court does not even have a self-imposed official code of conduct of the sort that would be applicable to justices or to judges on the lower courts. Instead, what has usually happened is that each justice and them sort of collectively as a group, not in any written document, but more in what you might call a vibes-based order, makes recusal decisions and polices their conflicts of interest and things like that. And so it's fair enough to say that, Justice Thomas, Justice Sotomayor, Justice Alito, all of these justices, none of them can be plausibly accused of having broken the law, right? Arguably, you can say that these things are ethically improper, but not in any sense that's been reduced to a binding code of legal conduct.
Okay.
The other thing you might ask, and we can get to this maybe later, is also they serve for life no matter what. So it's a little difficult to impose rules on people who hold their offices for terms of life, but perhaps that's another matter.
Yeah, I would like to get to that in a second. So taking us back to yesterday now, do you think, and this vote that happened, do you think this code of conduct is needed, or are critics blowing this out of proportion?
Well, the interesting thing is that the bill does not actually impose a code of conduct. What the bill says is that the Supreme Court is directed to adopt a code of conduct for itself. And it says that in certain respects, it can't be any less strict on certain things like disclosure than the Senate and House ethics rules. The Senate and the House of Representatives, those famously admired institutions for their ethical conduct, but whatever. So the bill doesn't actually contain a lot of substantive positions on what the justices can and can't do. It just says you have to adopt a written code, you have to publish it publicly, and then there have to be a sort of complaint process involving lower federal court judges who review complaints of misconduct for the justices, which is a little weird.
And it's weird. And you bring me to my next point. That's one of the things I found interesting, because if passed, this bill would establish that system to allow the public to submit ethics complaints against the justices. In your mind, is that a realistic change that could truly be incorporated into how the court operates, or would that mean a significant upheaval here?
Well, I don't know if it'll be an upheaval in the court's business, but I can tell you. So when I was a clerk for Justice Scalia, but before that, I worked on one of the lower courts, the Ninth Circuit Court of Appeals here in California. And the Ninth Circuit is one of the lower federal courts, so it has a complaint system for judicial misconduct because there's a set of ethics rules that govern the courts. And my perspective was that those complaints flood in from essentially all sources, pretty much unrelated to the merit of those complaints. And that's for a lower federal court. Most people are not even really interested or aware of the lower federal courts. For the Supreme Court, there is simply no doubt in my mind that if there were a public complaint system, that there would be thousands, if not tens or hundreds of thousands of such complaints filed per year. And this panel of lower court judges would have to review all of them. And it's not clear that they'd be able to give any of them a realistic amount of time.
Yeah, it would be an onslaught. One last question. I just have a few seconds left, Ian. If this bill becomes law, could the justices challenge it?
Themselves? That's interesting. Who would hear the challenge?
Exactly.
I suppose you could challenge it in lower federal courts, but, that would be a fun one. I hope that happens.
Okay, well, we'll follow it closely. Ian Samuel, thank you so much.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.